94.5 WPTI, 96.7 WTOB. And you're listening to the Wealth Guardians radio show with Doug Ray, helping you to retire the job and keep the paycheck. Today, we have Dennis Toman. Dennis is a board-certified elder law attorney, and he founded the elder law firm in Greensboro. He is a University of Wisconsin law alum and UNC School of Law alum. And when our clients have a legacy planning need, he's the one we refer to. Welcome to the show, Dennis.
Glad to be here, Doug.
Yeah, I'm glad you're here. You know, let's talk about the elder care journey, what you guys typically do on a day in and day out basis.
Yeah, it really is where this starts. Thinking about how we're going to help a family that is dealing with planning for the second half of life.
Yeah.
The question of, what's the right estate plan to have when they're a healthy, vigorous senior versus maybe when they're starting to deal with some memory or mobility issues.
Mm-hmm. Yeah. So in doing that, I know years ago, we've met probably 10 plus years ago, I had a client who was a veteran, and I found you because one of your specialties is aid and attendance, which is when a veteran can get a pension if they need home health care or nursing home care. And it's a little known benefit that veterans have. I used to try to do that for clients many years ago. And because the government is so slow in processing it, so many times that veteran would pass away before they got the benefit. And that just killed me.
Yeah, the aid and attendance benefit is something that is definitely overlooked all too often in the planning, particularly when we've got a veteran or even the surviving spouse of a deceased veteran who's living at home but needing some additional care or perhaps going into assisted living.
Yeah. Yeah, you know, we got a lot of veterans in the area, and if they're listening to the program today, I want them to know that that's there for them. There's a few guidelines to it. You want to talk about those first in terms of assets and so forth?
Yeah, well, absolutely. Well, it really starts with the veteran had to have had active duty during the wartime period.
But they didn't have to be in country.
But did not have to be in country in combat. They didn't be in combat and may even been in country the whole time.
Mm-hmm.
But, with that, come out of the service without a service-connected disability. Now they're over age 65, and based on their assets, based on their income, they can qualify for veterans benefit for the aid and attendance. Could be around $2,000 a month for a married veteran, less for the surviving spouse.
Well, I know that's a very specialized area of the law you practice in, but in your day-to-day affairs, tell me what the most common thing that you guys do over there at the elder law firm.
Yeah, really, the thing that we do more often than not is that for, middle America, people that, are in the middle, somebody that has lots of wealth, we're not going to deal with this so much. Somebody that has no wealth, it's really not as much of a concern either. But for somebody that's in the middle, the question is going to be they've, worked hard, saved hard, put some money aside. Now they're, at an age when they're starting to have some health concerns, that could be in their 60s, 70s, 80s. And how do we plan ahead to make sure that if they need nursing home care at $10,000 a month or more, that they're not going to impoverish the spouse at home, that they're going to be able to have money to live on, and that they can have options. And rather than spending all their money on care and being out of money and out of options, what can we do to plan ahead for that?
So it sounds a lot like Medicaid planning.
It is. It's proactive Medicaid planning.
Mm-hmm. And if I remember correctly, there is what's called a 5-year look back.
Yeah, absolutely. This would be something that we would do with a family where we're not needing immediate care.
Yeah. Yeah, if you need immediate care, it's a little bit too late.
Well, that's a good point, Doug. One of the things, though, that we always try to emphasize is that even in that crisis situation, there are still things that can be done. So We may not do the proactive type of planning in that situation, but let's say we've got a husband and wife and one spouse is going into the nursing home. The good news is that if they get the right help, take the right steps in the right order at the right time, they can generally protect pretty much everything for that spouse who's remaining at home.
Well, if you just joined us, tuning in now to the Wealth Guardian Show, we've got a very special guest today on the show, Dennis Toman. He is an elder law attorney, estate planning attorney in Greensboro, North Carolina, and he's the one that we refer our clients to. Dennis, I think one of the questions we hear the most often with people coming in to see us is, do I need a trust? And what is a trust? How does it work?
Yeah, you hear those too, don't you?
Yeah.
Exactly. And it's a great question. And of course, the short answer to it is that it depends on what they want to accomplish, what's important to them. And that really needs to be the conversation when they're dealing with their advisors is understand, well, what is it you're concerned about? And based on that, then we can decide whether or not a trust is going to be the best option for them. It's about the result, not about the tool.
There's all kinds of trusts, right?
Oh, absolutely.
Yeah. I got a question for you. If you put a trust together, do you need a trustee, and who is that trustee going to be?
Absolutely. Yeah. So a lot of times, that's one of the misconceptions about trust quite often is, well, if I set up a trust, that means somebody else is going to take over things. Maybe the bank even has to get involved. When in fact, most of the trusts that we're going to set up for estate planning purposes, particularly, we're going to have, a single person, married couple. If it's a single person, they're going to be their own trustee. Married couple, they'll both be the trustees. And so the people involved with the trust are going to be, well, who sets up the trust? That's the trust maker, sometimes called a grantor. Who is in charge of the trust? And that's the trustee, which can be the couple. And then who are the beneficiaries? And actually, if they're setting up their own trust, they're going to be the beneficiaries too, initially. Mm-hmm. And then provide for how that trust is distributed later if either of them became incapacitated or were to pass on.
Well, if you're listening to the show today and you've got, if this conversation has spurred some questions in your mind, feel free to reach out to either me or Dennis. Dennis, give us the audience your phone number.
Sure. We're at 336-378-1122.
Okay. And if you are, 7 years plus or minus retirement, or indeed even in retirement, I would ask you, if you have an interest, to give us a call and go through our retirement planning process. It's probably one of the most thorough processes you will ever have gone through in retirement planning. You need to get it right because you only go through retirement one time. So, Dennis, what other things do you guys do on a daily basis that you think is very important to the legacy planning stage of life?
Well, in addition to the Medicaid planning portion of that, and there's some situations where Medicaid is not going to be the option. Mm-hmm. That's not the desired goal. It's somebody that's in a situation where they're never planning to be on Medicaid. And in those situations, quite often we do use the trust-based plan with the idea of how best to protect the inheritance that the children are going to be receiving.
Mm-hmm. Let me ask this question. What do you think of long-term care insurance?
Yeah, absolutely. I think that in for the healthy, vigorous senior point of view, that's got to be one of the things to consider and, to look into long-term care insurance and the newer types even that are available.
Oh, we're 100% behind those. We try to do that planning as a part of our overall retirement planning process. It's something that we don't go into right away unless they ask us about it first, because our process is so thorough. Sometimes I'm afraid we're putting too much information in front of them. So if I bring in long-term care in the same process, it could be overwhelming. So we'll get around to the long-term care planning part of it after we onboard them as clients.
Well, that makes sense.
Yeah. Okay, so we've gone through trusts, and we've got a client right now that's going to be working with you for a charitable remainder trust, or there's a CRUT and a CRAT. You want to explain the difference between those?
Yeah. So the charitable remainder, actual charitable trust planning is a very interesting aspect of wealth protection. And so one of the options of being able to perhaps obtain a charitable deduction to offset income, and that often happens when there's appreciated assets that need to be sold and it'd be a lot of capital gains to pay. Then we can set up a charitable remainder trust that can allow us to have a deduction to offset that capital gain, and as a result, keep more of, can actually have the trust itself set up where it will sell the property and not pay any capital gains tax.
They're very powerful.
Yeah.
Well, we've come to the end of this segment, Dennis. It went quick. We have to sign off and pay some bills. Thanks for being here. Folks, stay with us. I'll have Dennis back right after these. Well, welcome back to the Wealth Guardian Show, where we help you retire that job and keep the paycheck. I'm Doug Ray. Brice is off today, but we've got a very special guest. That's Mr. Dennis Toman. We've been talking with him in the first part of the show. Dennis is an elder law estate planning attorney over in Greensboro, founded the elder law firm. He's a UNC law school graduate. And Dennis, how long have you been doing this?
For a long time. And so graduated back in the 80s, actually.
Yeah.
And worked with a couple of different law firms, and then set up this law firm in 2002. So this office itself and the people that we've got there, have actually got a 22-year-long employee.
Oh, wow.
We celebrated 22nd anniversary. So, yeah.
Wow. I guess they're making a career out of it.
I think so.
How many employees do you have?
Got 15 all.
Okay. Nice firm. Well, let's get back. We talked about in the first segment trust, the different kinds of trust, and who needs a trust. Let's talk about the difference between a will and a trust. Do you need both, or one or the other?
Yeah, and the way that we start is everybody's going to need a will. Everybody's going to need a will, even if they have a trust. Sometimes trusts are called will substitutes, but they're really not substitutes. They're used along with a will. And a will is really used if the main concern is, how do we take care of passing assets at death in the most, the least expensive way of doing that. And we're not as concerned about making things easier for the family. And so when we've got someone who says, well, one of my goals is, how do I make this easier for my children? Maybe they administer an estate for their parents and they figure there's got to be a better way to do that. Well, the trust allows for an easier estate administration, avoiding much of the probate hassle, the probate expense, and the probate invasion of privacy. And so for somebody who's got that as their goal, the trust is going to be better.
Okay. All right. Well, that makes sense to me. Well, folks, if you just tuned in, you're listening to the Wealth Guardian Show, and we're talking about estate planning with Mr. Dennis Toman. Dennis, what is the single biggest estate planning mistake you see?
Really, what I see more often than not is people fail to take into account their powers of attorney, particularly their financial power of attorney.
Mm-hmm.
And so we talk about wills, we talk about trusts, and certainly a big part of that is what happens if a person dies. But the power of attorney deals with, what if the person doesn't die and they need somebody to make decisions for them? Now, the trust accomplishes a big part of that. It's very important to have. But the power of attorney is overlooked so often because a lot of people assume they don't need a power of attorney. Their spouse knows what they want, or their children know what they want. And actually, in our country, if someone does not take the time to sign a power of attorney to name who they would want to make decisions for them, whether financial or healthcare, if they're unable to make their own decisions, well, then our law presumes that they never wanted anybody to do that for them, and they wanted the government to do it, which is the furthest thing from the truth. And so failing to have a power of attorney, having an outdated power of attorney, one that's been done, law changed in 2018 for financial powers of attorney, or having a power of attorney that doesn't have the right language in it. What I call, we need a powerful power of attorney, not just a bullet point power of attorney.
Mm-hmm. So in that regards, we have a couple clients actually that have children with special needs. And do you do a lot of special needs trusts?
Yeah, absolutely. The special needs trust is critical when we have a child who may need some government financial assistance, because too often the default estate plan is that, well, we'll just leave the assets to the other children and they're going to take care of their brother or their sister. And I have seen that go bad so many times.
Mm-hmm.
We need to have the inheritance protected for that child with special needs through the right type of supplemental needs trust or special needs trust. And it really relieves the burden of the other children, and it makes sure that things can turn out better for that child who really needs that help.
Yeah. Along those lines, I've been in this business 37 years now. When parents pass away and they have, a decent asset base that's going to be going to the kids, I've seen that gone bad too many times, especially in a situation where there's really nothing written down, who gets what, why, and that kind of stuff. I'm sure you've seen the same thing.
Seen the same thing. Yeah. The old saying is, well, everybody has an estate plan, even if they haven't written one down. The state, the government gives them their estate plan, mm-hmm. and it's usually not the one that they would want.
Yeah, that's exactly right.
Yeah.
Well, let's talk about probate a little bit. Tell the audience what probate is.
Yeah, probate is court-supervised estate administration. And so the key point to remember there is a will is simply a set of instructions. It has no authority to it whatsoever. The authority comes when the will is admitted to the court system, goes through a process of probate that then is a court-supervised estate administration. The process lasts anywhere from 6 months to a year for a typical estate administration. Something that's going to be more complex, it can last for 2 or 3 years, or sometimes even longer.
Mm-hmm.
And that's another reason for the trust to avoid much, if not all, of that lengthy probate administration.
So we're talking about probate. Let's turn our attention to the estate tax. There is such a thing called an estate tax exclusion. And how much is that?
Currently, over $13 million
per person. Yeah. So a husband and wife could theoretically shelter $26, $27 million.
Absolutely.
And it's just using the right combination of trusts, right?
Absolutely. And, you and I have been doing this long enough too, Doug. We remember when it was a lot less than $13 million per person.
Uh-huh. Yeah. And folks, what happens January 1st of 26, the Trump tax code goes away and it reverts back to the previous tax code, which is going to greatly reduce that estate tax exclusion. I think it goes down to what, 6 million?
Well, it's going to go down to 1/2 of whatever it is at the end of 2025.
Okay. Yeah. So that brings a lot more people into having to pay an estate tax, especially if you're a business owner, own a lot of real estate, a farmer. And here's the thing. The government doesn't want your farm, doesn't want your business. It wants cash 9 months later after death, right?
Absolutely. And the estate tax itself start at about 40% is what we're dealing with. And so, currently with families where they wouldn't be subject to the estate tax now, but they might their estate might grow. And they could be over the $5 or $6 million threshold per person. We definitely want to be incorporating some of the estate tax planning right now. And of course, this is all going to heat up even more next year when the question comes, will Congress change that or not?
So one of the tools that is used in estate tax planning, like I said a moment ago, the government doesn't want your business. They want cash. So one of the things that is done to pay that tax is using life insurance. Let's talk about irrevocable life insurance trust, ILITs.
Yeah, the life insurance has always been part of estate planning, and for a long time, when the estate taxes were relatively, started at a relatively lower amount, we were doing a lot of ILETs in order to pay for that. And we see that coming back too. And so for larger estates, the idea is that, life insurance passes to the beneficiaries income tax free. But the person who owns the life insurance, that's going to be part of their estate. And so estate taxes will be paid on the life insurance unless we have the irrevocable life insurance trust that owns that policy, or sometimes called an ILET.
We have a lot of clients that are in second marriages. I suspect you see that a lot too.
Absolutely.
How does that play into getting your wills and trusts and your estate plan together?
Well, it doesn't make it any simpler.
No, it's not.
I think there's two main focuses in that situation. Number one is that if there's wealth involved, we're probably not going to leave everything outright to the surviving spouse. And so we're probably going to use some sort of a trust-based plan for the benefit of the surviving spouse, and to the extent the money is still in that plan in that trust after their passing, then that can go back to probably the children from the prior marriage. The other that comes into play quite often is when somebody has gone through that divorce, they're recognizing that, well, what if I leave my inheritance to my children and they receive these assets, and then they go through a divorce, and my inheritance that they're receiving, the inheritance they're receiving from me, is going to go to somebody, maybe I don't like them that much, or maybe I don't even know them. So is there a way that I can better protect that inheritance for the possibility of my children divorcing?
Yeah, it's a complicated issue for sure. Well, for our audience, if this conversation has created, questions in your mind, let me offer to you to give Dennis's office a call. Dennis, the number again?
Yeah, it's 336-378-1122.
Yeah, write that down and give them a call, because you got to get your estate plan, you got to get it right, because you only, like retirement, you only go through it one time. And speaking of retirement, if you're interested in getting a thorough retirement plan done, in other words, retiring your job and creating that paycheck, give us a call at 336-391-3409. Let's close out with me asking this question. When do I need to do my estate planning?
My answer always is, call me the day before you have a stroke. And of course, but you have to tell me you're going to have that stroke the next day.
Exactly.
And that the point really is that need to do the estate planning now, because we never really know what tomorrow is going to bring.
My wife and I have done our trust and all that stuff many, many years ago. We were in South Carolina when we did it. Pretty soon we're going to come see you.
We'll look forward to that.
Dennis, thanks for being on the show today. I really appreciate it. And thank you, folks, for tuning in, listening to the Wealth Guardian Show. And we will see you again next week.